Today's calendar is number 86, Stefanik v. Hochul. Counsel?
Thank you, Your Honors. May it please the Court. I'm Michael Horelchek of O'Connell and Aronowitz, representing the plaintiff's appellants. I would like to reserve 3 minutes for rebuttal.
Yes, sir.
Thank you. Respondents' arguments for the validity of the mail voting law hinge critically on the supposed effect of the 1966 amendment to Article 2, Section 1. But this supposed effect is a fiction. It's a post hoc rationalization to justify the mail voting law. And there's simply no contemporaneous evidence whatsoever that this amendment of Section 1 was supposed to have any effect whatsoever on absentee voting.
But counsel, don't we have to take on its face the deletion of the only words that establish in-person voting?
So I think I would address that in a few different ways. And I think one thing, I think one of the counsel for the Commissioner Kaczynski is going to address specifically the historical background of that phrase, and we'll address that at more length. But I want to specifically talk about the change in 1966 and what meaning we can take from that. And I think, first of all, we're not talking about a deletion of one specific phrase. We're talking about basically a comprehensive rewrite of the entire section. And it was a simplification of the language that, before that time had various different provisions setting different time limits for different residents in different
well, in part, that intent and the purpose is to ensure greater access and to simplify the process. That, I think, cuts against your argument.
Well, I think if you look at the legislative history and not just of...
Well, do we have to even look at legislative history? The language is what the language is.
Right, but I'm saying if we look, and not just at the legislative history of this provision, but how the legislature looks at elections and access to elections in general, absentee voting has always been treated differently than other...
but this is not absentee voting, right? You think this is... If we don't think it's absentee voting, do you lose?
Well, just to make sure I understand your question, is the question that voting by mail is not a form of absentee voting? Is that the...
Yes, that's what I'm asking.
Well, that's not an argument that the respondents have pressed before this court. They had made that argument below. We just don't think that it stands up to historical scrutiny.
So if I'm at my home and I get a mail-in ballot and I mail it in from my home, I'm not absent.
I think so. The Constitution does not speak in terms of absentee voting, right? Section 2 applies to two categories, some of whom are people who are absent, and others are people who are ill or disabled, and but for that reason cannot personally appear.
Is there anywhere expressly in the Constitution after excluding the prior language before 1966 that says in-person voting is required?
Not in those words, but we think there are...
In other words?
We think there are textual indications that this is a background...
Explicitly, not implicitly.
Well, the language we would point to is that the Section 1 does say at the election. It uses the phrase at the election, which we think presupposes a physical place.
So is that the sole textual hook?
The other piece is, if we look at Section 2 itself, Section 2 refers to people who are unable to appear personally at the polling place. And that reflects the understanding that the normal way of voting is personally at the polling place, and an exception had to be made to enable people to vote other than...
Yeah, but that section was an exception to the prior language that did indeed. I don't think really anyone can disagree that prior to the 1966 amendment, and this court had said, the understanding of some of the language in Article 2, Section 1, was that it required voting at an election district.
So I think that brings us back, and again, I think that is the critical point.
But my point is, if that was an exception to that rule, and that rule is no longer in place, what Section 2 cannot possibly tell us whether or not in-person voting continues to be mandated, when there's no language anywhere in the Constitution.
So I think we need to understand it in the context of the history and the historical development of this language. And so if we, assuming as the premise that is the language that was the express requirement of in-person voting, there was a historical development starting in 1919 when additional amendments were made to allow additional categories of people to vote absentee. This is after the original 1864 amendment for military voters. But starting in 1919, a new section was created. It was then Section 1A. It was amended multiple times, 6 separate times. It was eventually renumbered to the current Section 2. And over the course of 50 years, there were 6 separate amendments amending this provision. And by the time you get to 1966, you've had a half a century of amendments to Section 2, where that was the focus of the legislature's efforts at absentee voting. Every time they looked at absentee voting, wanted to expand absentee voting, they were looking at Section 2. In
Yeah, but they
1960
were also looking at Section 1, because I don't think we can look at it in isolation, because 1 and 2 interplay together. 1 says you have to vote at the polling place, and 2 says there's an exception for these situations. But now 1 eliminates that. Whether that was their intent or not, those words are no longer there.
Well, just to be clear, 1 still does say at the election. It says you must vote at the election.
In person.
But not district.
It doesn't say in the district. That's
It's
the
at the
language that
election.
changed.
So you're voting at the election.
Right, but if you compare the language immediately preceding the 1966 amendment with the language that was enacted in 1966, and you see what the entire phrase that was the end of. You have a long list of the requirements of residence and citizenship, different lengths of time, and then it concludes saying in that district and no other district. And a legislator that was seeking to simplify and streamline and basically make more comprehensible that language in 1966, rewording that into a simpler phraseology. You can see how those words, if they weren't attuned to legislative debates that had happened 100
So
years
since it
earlier.
doesn't say election district, would you then read it to mean that one could vote somewhere else? And why couldn't that be at my home when I fill out the ballot?
Well, what I would say is that what the Constitution has always defined as the critical line in every time that the Constitution was amended to expand absentee voting, the critical distinction has always been in person versus through some other method, whether that method was proxy voting or mail voting or setting up special polling places for military bases.
Counsel, it seems to me you're asking us, this strikes me as of a piece with your negative implication expressio unius argument. Is that right?
Well, I think they're related.
But I guess my concern is this. I take it that you are asking us to infer from what you describe as, I think, the broader context of the 1966 amendment and what you say the legislature was trying to do, that there is a continued constraint on the legislature's plenary power that isn't set forth explicitly in the text. And so my question for you is, what case can you point us to where we have taken that sort of approach and taken a bite out of the legislature's power without some pretty explicit text in the Constitution itself?
Well, I think the Killeen case is a case where the court read in a implicit, applying expressio unius and read in an implicit limitation on the legislature's power based on the expressio unius principle. That's one case. There's also the.
I think your colleagues on the other side try to distinguish Killeen, but is that the best case you would point us to?
I think the 2 cases from this court that are examples of specifically limiting legislative authority to some degree are that case and also the Sill case, which was early case 1854, I believe. And again, that case, the particular legislative act that was at issue in that case, they upheld, but both the majority and the dissent in that case, it was unanimously the court, all of the judges agreed that applying expressio unius, there were implicit limits on the legislature's power that were not reflected by any express prohibition in the text of the Constitution.
And one other specific question, if I can. I believe that in 2019, the legislature amended the election law provision regarding domestic violence victims to allow them to vote by special ballot. I don't think that was done, although you correct me if I'm wrong, by constitutional amendment. So is that a sign that the legislature's view about whether or not any exception had to be done by constitutional amendment had shifted?
So what I would say is there's a few provisions, and that's one of them. There's a couple special ballot provisions that the respondents have identified as they're saying they're examples of the legislature exercising power beyond the Section 2 categories. What we would say to those is we don't think, these are provisions that affected a very small numbers of people, and there was no indication in their enactment. You can go back to the first of these.
But it seems to me either the legislature has the view that any exception has to be done by constitutional amendment because there's not any residual power, or it doesn't. So I'm not sure how, but tell me, how does the size of the group affected factor into that analysis?
Well, I think what we would say is there's no indication of what the legislature thought its source of power was for enacting those provisions.
So it wasn't a constitutional amendment because there wasn't one that was proposed. I mean, this was done, I think, by statute instead of a concurrent resolution aimed at an amendment.
Right. No, it was done by statute, but there's no statement. So, coming back again to 1966
But
again.
the only possible source would be Article 2, Section 7. We've said that's the sole enactment that gives plenary power to the legislature over the methods of elections.
I would give, so for example, I'm not standing here to defend or not the constitutionality of those other special ballot provisions, but I think,
But I do want to drill down on those a little bit, because there's 4 different ones, right? Election workers, caretakers of disabled people who themselves are not disabled, right? Domestic violence victims that Judge Halligan referred to, and emergency responders. And correct me if I'm wrong, but those all happened after 1966. Is that so far right?
Yes, that's correct.
And that there are no constitutional amendments to expand, absentee voting or mail-in voting or anything like that after 1966, excepting the failed 2021 ballot initiative.
So,
that right?
That is correct. And what I would say, though, is we can look at when the legislature has specifically spoken to the issue of its power to authorize absentee balloting. For example, in the 2021 proposed constitutional amendment, when the legislature talked specifically to that issue, they were very clear, crystal clear, that they did not believe they had that power, and they said they needed the constitutional amendment to give the power. Now, there are examples of times where arguably maybe they acted in excess of their constitutional power, but in none of those cases was there any engagement with the constitutional issue. Now, the one single piece, we look through the legislative history on those special provisions. The very first one, this is in 1982, when that was enacted, the only piece of legislative history that speaks at all, that alludes to the constitutional issue, is a letter from the Board of Elections, this in the legislative history, where they say in very explicit language, they distinguish this and say, this is not absentee ballot, this is not absentee voting, because this must be cast in person and cannot be cast by mail. And they say this is not absentee balloting. Clearly, at least some people in the Board of Elections felt that there was a constitutional infirmity, and they were trying to distinguish it to protect it. Now, subsequently, over those provisions have been added to little bit by little bit, and they've changed over time. But the legislature has never spoken to the source of its authority, and so I think when the legislature has been directed to the issue of what is your power under absentee voting, they were crystal clear. All the way up to 2021 and 2022. It was only when they wanted to forego the amendment process and just pass a statute to do what they couldn't do, get the voters to approve by amendment, that suddenly the legislature's opinion changes, and now they have this power that they previously said they didn't. And we think that that's...
So is it your argument that whether what they did was contrary to the Constitution is based on what they believed they had their powers, as opposed to what the court determines is or is not unconstitutional?
Well, those special ballot provisions, none of them had ever been challenged. So there's no court determination that any of those are or are not legal exercises of the legislature's authority. So we don't have a judicial determination on any of those.
Well, that's true with the 2021 referendum as well, right? There's no judicial resolution of that
Right,
either.
but I'm saying if we're trying to look at how what the Constitution and both Article 2, what Article 2 continues to means today, does that impose any constraints on the legislature? What is it? Does it have any continuing vitality, or is it just completely superfluous? What is the meaning of Section 2? And also, what was the impact of this?
Does traditional rules of statutory construction apply?
I think they certainly do. Yes, and there's a number of different.
Well, let me ask you this: do you read Article 2, Section 2, to require the legislature to provide for, other than in-person voting, for those designated subcategories.
No, and it does not, by its language, it says the legislature may, it's a permissive power, and there are also several court decisions over the years, and an opinion by the Attorney General that has said that this is permissive, and the legislature is not required to provide for any of those people through Section 2.
So going back to Section 7, I guess, in the 1894 amendment,
Yes.
is your interpretation that the legislature could allow voting by internet? Assuming it was secure and, met the other requirements.
So again, right, as far as, we believe Section 7 spoke only to the method. So could you set up a computer terminal in the election polling place and have people use that computer terminal to enter their votes? I think that would, probably be within their authority to set the method of election. But place of election has always been treated differently. Every time that...
Well, is there a constitutional restriction on where polling places can be?
I would have to, I don't believe there's a specific.
Could my home be a polling place?
Well, I mean, that would be adopting it's how far can you stretch a legal fiction? That's a question for another case.
Well, what if you were invited to vote there too? Or the lobby of my building, or?
So, but what I would say is, the Constitution has, every time it's been amended, every single time it was amended to allow
Let me
absentee
ask
voting.
it this way. When I read legislative history around the 1894 amendment, it looks as if there was quite a lengthy debate about whether the amendment was to be not adopted at all, was to be adopted to limit it to voting machines, or instead what they wound up with, which was method of voting. And the discussion around that, what was ultimately adopted, was that they couldn't predict what the future would hold in terms of methods, and they were going to leave the method entirely to the legislature. Is that fair or not fair?
In part, but what I would say, I would distinguish in two different ways. First of all, if you look at their discussion of other methods, there's no indication they were thinking of place of election or absentee voting. Absentee voting already existed at that time. It had already existed since 1864. There's no mention in any of the discussion about absentee voting or place of election, only about the specific, they're talking about voice votes
when
or
they're thinking
ballots or
about
machines.
absentee back in the 1800s, they're thinking about people who are not in the state, basically, right?
Well, the 1864 provision applied to people that were outside of the district. They didn't have to be outside of the state to vote absentee.
Yeah, but they were thinking about people fighting for the Union Army, and they were, by and large, not fighting in New York. They were fighting elsewhere.
Likely that many of the, yeah, that's probably true of many of them, I'm sure. But I would also say, in 1894, they could not have been authorizing absentee voting or remote voting because, as we've talked about at that time, that specific language in Section 1 was still in place. So to look at Section 7 as authorizing this remote voting, you have to think, well, somehow that sprang into effect, that Section 7 broadened and gave them this power of absentee voting that they previously didn't have due to the 1966 amendment. I mean, clearly that wasn't what they were contemplating in 1894 because that was already, Section 1, as it had been interpreted, prohibited that. So I think to read backwards and say, well, we think that that years later, an expanded Section 7 power sprang into effect. I think that's it's hard to read, to see how that's plausible.
Thank you.
All right, thank you.
Good morning, Your Honors. Nicholas Faso from Colin Dyckman on behalf of Respondent Peter Kaczynski. This court should reverse because the lower court erroneously held that the election district provision was the source of the Constitution's in-person voting requirement.
So what is the source of an in-person requirement?
It's the preposition at. And we know that because before the election district provision was enacted, voting, and that was in 1821, voting was always conducted in person. There's no dispute about that. From 1777, New York's first constitution, voting was done in person. We know that, given the historical realities of the time, but also because at that time, voting was done viva voce, by voice. Everyone came to the...
But if it meant what you say it means, they would have retained the word district, right?
Retain the word
The
district.
word district. Right, you're saying the textual support for in-person voting is the phrase "at every election." Am I understanding you in Section 1? But if it meant what you say, if it means what you say it means, why would they have deleted the word district?
In 1966, I believe they deleted the election district provision because it had become an administrative impossibility. We can only speculate because there's no legislative history.
Well, then why not say at a polling site?
Because there was no need to specify that, because the only way you could possibly cast a vote was traditionally at a polling site.
Yeah, but the only time you vote is at an election. One does not vote other than during an election. So I still don't see how you get to your view of this language.
Oh,
It
fact
seems
that
to
this
me
li-
it's like saying to vote in an election. I mean, at the end, you've also got next preceding an election. It doesn't seem to do the work you say it does.
in and at have different meanings, and words should be construed to give their ordinary meaning.
But counsel, at has multiple meanings. I haven't checked Webster's, but OED defines at as a preposition designating the place of a happening of an event, and secondarily as a preposition designating the time of the happening of an event.
Yeah.
So what makes you so sure that at is being used in its locative sense as opposed to its temporal sense?
Two reasons. First, the historical tradition of viva voce voting, and that's what was occurring with our first Constitution and continued for some time. Secondly,
But that seems,
yes,
that
at
seems
can
to cut against you a little bit, because there wasn't really another way to vote at that time, right?
Surely there was paper and ink at that time, but that was unheard of to use, because voting was never private. It was done in person and by voice. And so that was the historical tradition. But to go back to your question, Your Honor, in and at have similar meanings, but here it's very specific. One could say you are in school or you're at school. In school means you're currently studying. At school means location at a building. One could be in
Yes,
prison
but the
or
problem
at
here
prison.
is that the at is being used to, the preposition is being used to modify an election. And an election is a huge statewide undertaking, and I think the problem that I'm having with your strictly locative use of the word is that at could mean any one of hundreds of different polling places. It doesn't lend itself very well to your suggested use of it, but when you think of it as a temporal indicator on the occasion of the election, it, to me, makes a lot more sense. So my leaning would be to look at it as a temporal fixer and not a location fixer.
Well, we know this is true from the legislative history as well. For example, at the 1821 convention, one delegate observed that every man who has property to protect will attend the election. Elections were understood to be events at which citizens came in person to participate. They were in the town center. It was a very raucous scene. You may have seen the painting by Brigham.
Can I ask you to just switch gears for a quick minute and ask you a practical question, which is there a difference in the mechanism that is used? My understanding from the briefs is that there have been mail-in ballots provided already. So is there a difference in the mechanism between absentee and mail-in ballots?
No, I don't think there's any difference, and in fact, the early mail voting statute says that you should construe every instance of early mail voting to be consistent with absentee
But I just
ballot.
mean in terms of the administration of the election itself. Do you access and submit an absentee ballot in the same way as a mail-in ballot, if you know?
Yeah, I mean, the statute effectively replaced absentee balloting with early mail voting, and you can compare the two and they're identical except for that semantic difference. So they are functionally the same, and they operate in a similar way.
But they need not be, right? I mean, under Section 2, could the legislature come up with a different way for those subcategories of voters to exercise the franchise? And let everyone else just have early mail-in voting or going to a polling site?
The only suggestion of a different way is to compromise secrecy in balloting. And so I don't think that's a very plausible rationale for Section 2 remaining in the Constitution. And that's the only
But that's the
rationale
point of the
that's been offered.
flexibility. That, perhaps you are correct now, but next year, who knows? There may be something that the legislature feels comfortable with and wants to provide specifically to that group.
We
There
know-
are already special procedures that apply to people who cannot physically go to a polling site.
We know that the legislature understood that it was constrained by the Constitution to allow mail voting. We know that because they passed the referendum in 2020.
Well, let me ask you this. Are you in agreement with the other attorney for the other plaintiffs that Article 2, Section 2 is discretionary, not mandatory?
Yeah, it's clear. It says may.
Okay. So the legislature, theoretically, tomorrow, right, could require that the subcategories that are in Section 2 go to a polling site.
I suppose that's possible, but I don't think
Why
that-
they would do it politically, I don't know. But my point is a theoretical exercise.
There's no dispute that the legislature has acknowledged that in-person voting was required. And I point to this court's decision last month in the United Jewish Community of Blooming Grove, a unanimous decision. In that decision, the court noted that where the legislature fails to act, that there can be an acquiescence by the legislature to a commonly understood interpretation of a statute. I submit that the reverse is equally acceptable, that where the legislature takes action in reliance on a widely understood interpretation of the Constitution, that context constitutes an express recognition.
Something that constrains the legislature's otherwise plenary power, we might think about differently than the way in which we apply those canons to a statute. Don't you think?
And we think the Constitution does constrain the legislature in enacting any type of voting.
So you
is
think
not-
that independent of application of any canons of construction?
Yes.
Because of in
Yeah,
Is that
I mean,
your
and-
best argument, the at versus in, and do you think that's sufficient to sustain the high burden of beyond a reasonable doubt?
I do think it's sufficient. I mean, we also agree with the appellants on the negative implication of Section 2. But this court is very clear that we have to give meaning and effect to words used in the Constitution and in statutes. And the appellate division's decision only worked if they construed at to mean in.
Do you agree with your colleague that Sill and Colleen are the two examples in which he argues, I realize the other side has a different view, but he argues that this court has found a constraint on the legislature by virtue of negative implication as opposed to explicit text?
Yeah, I mean, our briefing didn't focus on those issues as extensively as appellants, but I do agree.
But there's nowhere else you
that
would point to, as I
Killian and
take it.
Sill, yeah, do have that effect.
Thank you, Counsel.
Thank you, Your Honor.
Good morning, Your Honors. Jeffrey Lang on behalf of the state and the governor. The Early Mail Voting Act promotes important state interests, allowing voters to exercise the franchise more easily, and plaintiffs haven't met their heavy burden to show that it is invalid. As an exercise of the legislature's plenary power, this court has said on many occasions that the legislature has plenary power to pass reasonable
What do you
voting
say
laws.
with respect to their argument about at the election versus in the election?
Well, I think that's plainly wrong. I mean, so they're trying to say that the in-person requirement for voting preceded the addition of what we've called the election district provision, the specific reference to an election district, based on the simple fact that the Constitution, Section 1, Article 2, Section 1, used the term at such election. But in fact, when the drafters of the Constitution wanted to refer to a location, they said at the polling place. In Article 2, Section 2, it's if you're not able to personally appear, not at the election, at the polling place. The term election just refers to a process of selecting an office holder, and the Supreme Court decision in the Love case, I think, is very clear about this. I would also say that in Article 2, Section 3, this just confirms my point. If you take a bribe for a vote, or if you wager on the outcome of an election, then you are not allowed to vote. And the language literally is at such election. And you could not get around that rule by saying, oh, I voted absentee, I didn't vote at such election. And when the drafters of the original, Governor Seymour, who had proposed the original amendment because he thought it was required, what he pointed to was not the bare use of the phrase "at such election" or "now it's at every election." He specifically pointed to the election district provision.
So, counsel, with respect to the election district provision, your briefs, most of the respondents' briefs, sort of use this hedging kind of language that it's commonly understood or was, it doesn't say that it actually requires in-person voting. It says that was the understanding that grew over the years. So have you, for purposes of this argument, conceded that the election district provision was an in-person voting requirement, or is that still open to debate?
I think it is. I think it was reasonably interpreted as an in-person requirement, and in fact, that's how it was, in fact, interpreted.
But if you look at the legislative history for it, is it a different reasonable interpretation that it was intended to make sure that people were voting for the candidates who were going to serve them and not for candidates in the neighboring town or village or county?
Sure, I mean, that was plainly the intent, but I think the effect of that, which people understood, that's what Governor Seymour said, was to impose an in-person requirement.
Right, but the question is why? Is it because you wanted to make sure people were voting for their representatives and not somebody else's, crossing over to throw an election, that sort of thing? Or because there was some public purpose in having people get together at a polling place who were neighbors and seeing each other and for fostering some sense of civic responsibility because they're in the right place as opposed to voting for the right people?
No, I think it was probably the first, but at the time, the only way to satisfy that requirement that you vote in the election district was conceived to appear personally at the polls and cast your vote.
Wasn't there a general concern? Wasn't there a general concern then beyond this, and I think it's expressed by Governor Seymour and certainly by Seward later, that about fraud? I mean, it was fraud that drove some of this consensus, or however you describe it in various filings. But so isn't that the balance that's being struck? It's between fraud and the potential for fraud, and by the same token, confidence in the process and universal suffrage.
I mean, there may have been some concern. I mean, I guess I haven't seen that. I mean, the concern with absentee, and I think the better term would be remote voting. It just all I mean by that is you're not personally appearing in person at the polls. It was noted by Governor Seymour, but then that specific language about appearing voting in the election district in the 1867 Committee on Suffrage, which wanted to add to the Constitution, there was already the provision for soldiers and.
If I could just pick up on a thread that the Chief Judge put out there. Your colleague for Kaczynski makes the argument that the election district provision is really a residency requirement, that there's nothing to be interpreted in there to come to the generally accepted historical position that that's an in-person voting requirement. And that's sort of consistent, I think, with the Chief Judge's point that it's to make sure that voters are voting for the people who represent them and not, to help some candidate in some other district. So do you reject that interpretation out of hand, or might that also be
No, I mean, that
plausible?
might be correct. I guess what I would say is our position doesn't stand or fall on whether the election district in fact required in-person voting.
I want to press you on that point, if I can, counsel. I went and looked at your briefs in Cavalier and Amador and Ross, and just reading from the brief in Cavalier, which was just 2 years ago, you said the Constitution has generally been regarded as continuing to retain the requirement implicitly, and I think it's fair to say those briefs proceed on the assumption that that is, in fact, an accurate reading. And you say something very different here. Here you tell us that the in-person voting requirement was removed, and thus there is no constitutional impediment to a statute that permits all voters to cast their ballots by mail. I guess what I'm grappling with is, if in fact there is no constraint to passing a statute, along the lines of what your adversaries argue, why wasn't that the crux of the argument in Cavalier and Amador and Ross that you presented?
Well, because that wasn't the issue in Cavalier and Ross had to do with the legislature's statutory authority to clarify the
You don't
meaning
think
of
there's any
sick.
inconsistency?
Sorry.
Go ahead, sorry.
Could we have made an alternative argument that the argument that we are making today? Sure, I suppose so, but that's not what we were focused on. We were the issue before the court was that a proper interpretation of what it meant to be sick within the, under Section 2 of the Constitution, Article 2, Section 2.
So you think there's no inconsistency between your reading of what the impact of deleting that language is, which today I think you say is significant, and the approach in those other three cases?
Well, I don't think there's an inconsistency, and the reason that we say it's significant is because the election district provision, again, whether this was ultimately correctly read or not, historically, just as a matter of fact, it was read by multiple parties, the governor, the legislature, the Committee on Suffrage that I mentioned, it was taken as requiring an in-person vote, as requiring in-person voting at the polls. And that explains why the legislature went down the path of the constitutional path of
I guess it just strikes me that if this was a solution to the question, that would have been presented to the third department in those other cases.
Well, had we undertaken the historical analysis that we've now done, we could have made that argument. I can tell you I participated in those cases that we were simply focusing on the statutory construction argument.
What about
not the
here,
argument we're making
the
today.
will of the people? If we adopt your position, aren't we ignoring the will of the people, which spoke pretty emphatically when they rejected the amendment? How should we grapple with that? How do we reconcile that?
Well, I'll say two things. This court has repeatedly said that very little can be inferred from any type of failed enactment, and that would include a failed constitutional amendment.
Do you think this is different than a legislative enactment, like a failed bill, versus an amendment that was put to the people? I would imagine that it cost a lot of money to put this to the people on the ballot, millions of dollars, and the people spoke pretty clearly. Legislation gets passed or attempted to get passed for any variety of reasons. I don't think they're the same. Do you?
I understand there's a difference, but I don't think it should be dispositive in this case. In other words, I don't think this case should turn on the failure of that 2021 amendment. What I would say about it is there certainly was a view at the time by many that a constitutional amendment was required to enact universal no-excuse voting, and some may have thought, well, maybe if not strictly speaking necessary, it would be the prudent course to take. They attempted to pass it. It failed at the polls, and a new legislature took a fresh look at the issue and determined that it had the authority to enact remote voting. And that, I would add, is consistent with the four statutes that Chief Judge Wilson had noted earlier. None of those statutes are consistent with an in-person at the polls voting
Can I
requirement.
ask you about specifically one of those? Let's start with 1982, I believe. And in 82, the law said, election law provision said, a written statement is necessary that he or she will be unable to appear at the polling place for such election district on the day of the election, which pretty much seems to track the language in Section 2, which says they can do this for those that may be unable to appear personally at the polling place, right? So did they even change the absentee
But you're unable to appear. Sorry.
I'm sorry, go ahead.
No, you're unable to appear under Section 2. If you're unable to appear at the polling place, it has to be because either you're sick or you're disabled, right? Those are the two conditions in Section 2. And so being unable to appear because you're a polling worker, that wouldn't fit Section 2.
So
the same
did
for
they
domestic.
change the ballot, the absentee ballot form after they passed 82 legislation? Did they have to change the forms? So when I mail in my ballot and I'm a polling worker, you know, or I request an absentee ballot, I guess it would be. Do I have to say something different?
I don't know what the application currently includes. My only point is that those 4 laws
Well, now it's
cannot,
very different, right? I mean, that's why we're here. But
Sure,
back
but-
then, did an election worker have to say, you know, I'm not going to be there? Or did they just put that on the regular absentee ballot?
Your Honor, I don't know the answer to that question, but even if they had to say that they couldn't be there because they were working at the polls, that still would not fall under the Section 2,
Well, you seem
Article
to
2
make a very
amendment.
different argument about stretching Section 2 in the COVID case, right? I mean, that was so expansive, it covered that. I mean, when you were challenged on, could you do COVID, let's call it the COVID legislation. I mean, then Section 2, well, the argument on the other side was technically does not apply to this. The position of the Attorney General's office, I think we just heard, was no, 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 this fits within Section 2. So it seemed pretty elastic back then.
Well, I mean, we had a reasonable interpretation of what it meant to be sick, which was that if you were afraid that you would either catch an illness, you were at risk of catching an illness, that fell under the exception for being unable to appear because you're sick. That was obviously prompted by the pandemic. I don't see that as inconsistent
Well,
with
I'm
anything.
working in a polling place that isn't my own and I can't leave. Isn't that I physically can't appear?
Yes, but my point is, it's not just you physically can't appear for any reason whatsoever. In order to invoke Article 2, Section 2, which, you know, on their theory, there's an in-person requirement to appear, and it's only subject to the exceptions in Article 2, Section 2, and one of those is unable to appear because you are disabled or because you are sick. And if you cannot appear
So
because you are
but your view in
working,
that case was
you don't
being
fit.
afraid of getting sick fit under the language of Section 2, though.
That was what we argued in those cases, and it's what the Fourth
Can I
Department
ask you,
ultimately held.
your adversary argues that your reading renders Section 2 superfluous, and you argue, I think, correct me if I'm wrong, that Section 2 would authorize some different kind of mechanisms, perhaps, you know, that don't adhere to secrecy. Are there any laws that have been passed that, in your view, are authorized only by Section 2, but wouldn't be authorized under your reading now of what the legislature's power is that allows the mail-in ballots for everybody else?
Not that I'm aware of, and it could well be that, you know, Section 2 becomes largely redundant. But at the end of the day, I think you have to give effect to the deletion of that very key language.
Can you, I know your light's on, Chief, if I could just briefly follow up. Are there any other, I really don't know the answer to this question, but you might, are there any other constitutional provisions you can point us to where a reading of a different provision essentially renders some other provision, if not totally superfluous, then as you say, largely redundant?
Well, I mean, not even a reading, actually. Since the 1864 Article 1, Section 1 always had a provision to allow for soldiers to vote absentee. That was actually retained until 1966 when it was deleted. But in 1919, there was a provision for the legislature to allow people to vote absentee if they were required to be away. And so for a period of almost 50 years, you had a redundancy in the Constitution that wasn't cleaned up. I want to make just one final
Well, isn't
point.
section, if I can just on this, if I may, isn't Section 7 the redundancy? Because if section, I assume you agree with the other lawyers that Section 2 does not require that those category of eligible voters be given some other way to vote other than in person, that Section 7 does that job. Is that not correct?
Yes, Section 7, I mean, I think they are just overlapping independent authority for
So-
the same thing. And, you know, again, you could say if the legislature is maybe acting at the limits of its plenary authority, Section 2 would provide a source of independent authority as to the persons covered by Section 2.
What's the
And
purpose of Section 7? I heard, I think in the brief somewhere, and I thought I heard a question that says it gives the legislature plenary authority. My understanding of plenary authority is that the legislature has that. You don't have to give it to them. You can only limit it. So if they have the plenary authority to do what's in Section 7, why isn't there?
Well, I think it just I mean, I think you can look at the plenary authority as either the legislative authority, the authority that's given to the legislature in Article 3 of the Constitution. This is a little bit more specific. It's another, and this court has actually said in multiple cases that, you know, Section 7 can be seen as giving the court broad authority to enact reasonable voting regulations.
But why would they need it? I mean, don't they have that? Isn't that their plenary authority?
I think they would have that plenary authority if Section 7 didn't exist in the Constitution. So all I'm saying is it's additional authority. I want to make one final point, which is that plaintiffs have said that our argument about the election district provision and its deletion and the effect that the deletion should be given was a post hoc argument. But in fact, in a document that plaintiffs themselves cite, this very argument is noted. It's the Temporary State Commission on the Constitutional Convention of 1967. It's page 50. And the drafters of that report note the very argument we're making. They note that there used to be in the Constitution what we've called the election district provision, and that it was deleted, and that one could infer from that the legislature now has plenary authority, now has full authority to enact remote voting.
But don't they say at the very end of that quote, this interpretation, however, makes Article 2, Section 2 superfluous? Almost as, I think they give both interpretations.
Yes, I agree with that.
With the second one, they say, however, the second interpretation, your interpretation, makes Section 2 superfluous.
They give a counter argument. So, and I don't think they conclude one way or the other. All I'm saying is that the notion that the deletion of this language had no effect, it's not something that was thought of for the first time in 2023. And then the legislature proceeded to act consistently with that understanding on no less than 4 occasions. For these reasons, we would ask the court to affirm.
Thank you.
May it please the court, Aria Branch for the intervener respondents. In its current form, the New York Constitution contains no requirement, express or implied, mandating that voting occur in person. I'd like to respond, and so we would ask that this court affirm the decision of the Third Department and uphold the Early Mail Voter Act as
Counsel, can I
constitutional.
ask you your view? It seems to me, you know, we've gone back and forth a lot about the text, but it does seem to me that there was a view that a constitutional amendment was required, and the sponsor's memo for the failed amendment, right, with respect to the resolution, says the same thing. It says, historically, the New York State Constitution allows absentee voting in extraordinarily narrow circumstances and addresses Section 2. So my question is, as an interpretive matter, how does this longstanding understanding that the legislature apparently had, I realize we have the 4 statutes, that I have to think is what motivated the effort to put this on the ballot. Were they just mistaken all this time? How does that bear on the way we look at the interpretive question?
Well, I think the important thing to focus on is that the question before the court is whether or not the Early Mail Voter Act is constitutional. And what the 2021 legislature thought about you know, whether a constitutional amendment was required is just not legally dispositive.
So
and
if the
doesn't bear
public
on
and
that
the
question.
legislature operate under the premise for a long time that a constitutional provision means X, then I take it your argument is we should sort of put on textual blinders and look only at what the words say, and if the words say not X, that's the end of the discussion, and the you know, the views that the legislature and perhaps the AG proceeded under are not relevant?
I don't know if I would say they're not relevant, but they don't control here. I don't think they control the constitutional question, and I don't think they're enough to meet the plaintiff's burden of proving beyond a reasonable doubt that the act is unconstitutional.
That point is well taken. And, the precedential effect of a negative vote is certainly open to debate. And you have a good argument on that. But, and there was a question before, which was along the lines of, how do we deal with it, though? I mean, the ultimate sovereign here is the people. That's where all the power comes from, whether it's given to the legislature or contained in the Constitution. And they did speak not very long ago in a negative manner. And I think it would be sort of, I don't know what the word I'm looking for is, dismissive of this court to ignore that happening. So it has to be dealt with on some level. So I'm going to ask the same question that was asked of one of your colleagues before. How do we deal with it? What do we say about the fact that the people, kind of decisively turned down this very thing?
I think, like you said, we can't draw a negative inference based on what millions of voters, rejected or supported. And so this court has very clearly said that in Golden v. Koch that it's basically a fool's errand to try to divine the intent of millions of voters who have rejected a constitutional amendment.
Does that depend on what the amendment is, though? First, in terms of what the subject matter is, and second, in terms of what the people were told and what the change would have been.
Well, I think in this case, what we do know is that the Early Mail Voter Act was passed by the legislature, and it was signed into law by the governor. And we know that the legislature is responsive to voters. And if voters decide that they disagree with what the legislature
than the people that voted in the amendment process, the legislature knows better.
Well, I think they speak for the voters of New York, right? They are not an unelected body.
It seems, going back to Judge Canataro's point, the people speak most directly in the Constitution, right?
Right.
I mean, that's direct democracy as you can get.
They rejected the amendment, and we don't know why they rejected the amendment. What we do know is that the law was passed by people who represent the voters of New York, and if the voters of New York disagree, they have recourse. They can vote those. They can vote their representatives out.
To Judge Canataro's point or question, maybe, if you go into the voting booth and you look at all the amendments on the back page of the ballot, and you're a voter and you go through all of them and you check no and you read that that amendment was defeated, it's got to be surprising for sure if you were to learn that the legislature nonetheless proceeded and that the court said that that was okay. I guess what I'm asking is, doesn't that erode some public confidence in the process to take that route?
I don't think it does, because in this circumstance, we're talking about legislation that makes it easier for voters to exercise their constitutional right to vote. The express purpose of the Early Mail Voter Act is, quote, to ensure the ease of participation in elections and to make New York a leader in engaging the electorate.
Going back to the original question, when those propositions that are on the ballot, you're asking the voters for their input. And there's a concern that it's said, well, it doesn't matter what you think, we know better. But they were asked, and they said no. And you're saying that doesn't matter?
I think, that is an argument that has been made. I just don't think it is enough for plaintiffs to meet their burden of
legislators often act against the desires of their constituents. Is that not the case?
That's true, and it's also true, we don't know
And they pay
why.
a price at the ballot, do they not?
I'm sorry?
They pay a price at the ballot.
They pay a price at the ballot.
So if we were to uphold this act, and the majority of the people of the state of New York disagree, they have their
recourse.
They have their recourse at the
That's
ballot. It's a
exactly
political
right.
question.
Is there a view, a reasonable view of the Constitution that it never contained an in-person voting requirement?
I think there is, Your Honor. I think there is a reasonable view of the Constitution that it never contained an in-person voting requirement. I certainly don't think it is located in the at every election language.
But would you also say that it would be a reasonable position to take that for 150 years, people believed that there was a restriction like that? And by people, I mean the legislature, the executive.
I think that's correct. I do. There are numerous.
So then that's kind of the conundrum of this case in a way, right? Is that on your side, you have the strong presumption of constitutionality of legislative acts, and you have that there really, if you're looking for some clear text in the Constitution that would restrict the legislature's power, it's hard to find. It requires a lot of, twists and turns to get there. And on the other side, you have a pretty common understanding for a century and a half that from somewhere there was a restriction like that.
There was a common understanding that there was a requirement to vote in the polling place, or at least that that's how the right to vote was exercised. But once the 1966 amendment was passed and the election district provision was removed from the Constitution, there was no longer a textual basis for an
Do you
in-person
think
voting
that,
requirement.
in your view, the 1966 amendment was it would intentionally remove that requirement, or it was accidental?
It's a good question, and I think that there is at least one contemporaneous source that we have that actually came up in plaintiff's brief, in their reply brief that my colleague just mentioned, from the 1967 Constitutional Convention
That says it could be read
recognizes-
either way, and this has the problem, and that is just a post hoc, we don't know what happened kind of statement. But what evidence is there that it was done intentionally contemporaneous with the 66 amendment process?
Well, I think there is not a lot of legislative history around
But
the
is there
1966
anything at
amendment.
all, anywhere, that indicates that the intent, other than, I understand your argument based on the text, but is there anything outside the text that indicates the intention was to have the people remove that requirement?
I think the closest thing we have that's nearly contemporaneous is the report to the delegates of the 1967
So let's say
Constitutional
it's
Convention.
accidental, right? There was no intent one way or another, it's just that's the result based on your language, your textual argument. Going to the Chief Judge's point, is that the way to get rid of a 150-year-old rule that people accept as the balance between whatever benefit this legislation may have and faith in the process because of concern with how it's administered? So is that accidentally stumbling into removing that language something that then we should give that effect to?
I think the strongest indicator we have of legislative intent is the text. And what we have here is the fact that there was once language that people thought required voters to exercise their right to vote in a polling place in person, and that language was removed. And now plaintiffs want to engage in this type
So
of
then,
zombie
is your
constitutionalism.
position that we do not look at the legislative history? We're bound by the text because the text is clear, there's no requirement in the text of the Constitution.
I don't think it's necessary to look at the legislative history here. There certainly isn't anything that says that, that in the legislative history that adopts plaintiff's argument. And I mean, legislative history is important when there is ambiguity. Here, there is no ambiguity. The text once had a requirement, it no longer has it, and therefore, there is no requirement to vote in person
Isn't there a
in New
difference
York.
between interpreting a statute and the Constitution? Shouldn't we be more amenable to looking at purpose and intent when considering the Constitution versus a statute? Do you think that's a significant difference or no?
Well, I think here, when you're looking at purpose and intent, you're looking at the historical context of the 1966 amendment. And at that time, there was a provision that required voting in person in the election district provision. Section 2 provided exceptions to that rule.
But
Right, so
why
they
is,
might have
why
felt
is,
that
sorry.
Section 2 covered that.
There's no indication anywhere that people thought that the rule became embodied in the exceptions to the rule in Section 2, and none of the cases that plaintiffs cite where expressio unius is used involve this court relying on exceptions to create a rule. That
Why
just
is
hasn't happened.
the relevant reference point 1966 specifically? You know, the Supreme Court has suggested looking at history and tradition to understand the meaning of various constitutional amendments. Why don't we look, as the Chief Judge, I think, was perhaps asking, at the tradition of understanding the scope of the legislature's power for 100 or 150 years before 1966 as well?
I mean, I think that the 1966 amendment changed the understanding of the in-person requirement to like all of the historical sources. We have Governor Seymour, we have the Lardner case, we have the commission report from 1967, and we have a 1946 Attorney General's opinion.
What about 2021? You have 2021, where I think the person who introduces some of the legislation says, we need this because the Constitution prohibits us from doing this.
Right, and we do have that, but I don't think that that is legally dispositive. That standing alone really is not enough for plaintiffs to meet their burden that the law is unconstitutional. It's simply not legally dispositive what legislators thought in 2021, 60 years after Section 2 had most recently been amended. It's just not legally dispositive on this question. It is not enough for plaintiffs to meet their burden. It's possible that the legislator thought as a political or as a legal matter that it would have been easier if no excuse absentee voting became part of the Constitution through constitutional amendment, not through the legislature to foreclose a challenge such as this one.
Can I ask, what, earlier on in response to the Chief Judge's question, you said, yes, there is, or something to this effect, there is an argument that there was never an in-person requirement, and then it just becomes a practice and an understanding. What's the basis for saying there's no in-person requirement?
I mean,
If we read the Constitution that way, what could it possibly be?
So I think there is a basis for understanding the election district provision to require people to vote in their election district and not necessarily at a polling place. But that is not how people interpreted it. That's not what Governor Seymour thought when soldiers in the Civil War needed to be authorized to vote remotely. And so if the election district provision did not require in-person
I'm sorry,
voting.
you got to work that one through for me. So what would that mean? That I physically cannot leave the election district, but I need not go anywhere to vote? What am I doing with the ballot?
Yeah, I mean, I think the best reading.
How would I get the ballot?
I think the best reading is that the election district provision did require in-person voting. There is a reading, and that is how it was understood. That is what Governor Seymour thought in 1963. That's what numerous historical sources have said. And so I think that once that in-person voting requirement that's in the election district was removed, there's no longer that requirement.
Do you know what
right?
the collection mechanisms were for the exceptions set forth in Section 2? Do you know how you would actually deliver your ballot? So if you were a soldier, for example, or any of the other categories set forth?
My understanding is that the soldiers actually voted by proxy, and so I think someone delivered.
Do you know if any of them were by mail, any of the other exceptions?
I don't know. I know that what became Section 2 is extended to apply to soldiers and then
Right.
commercial travelers. There may have been voting by mail. There is in the legislative history of Section 7, the 1894 amendment, where the by ballot or by any other such method language was added. There is some discussion that that language would allow voting by mail, and no one disagreed when a legislator raised that as something that might be advanced. So I know it has come up in the context of the legislative history of Section 7. I'm not as certain with respect to Section 2.
Thank you.
Thank you.
Thank you, Your Honors. There was some discussion about the role of the people in the constitutional process, the role of the voters in being a check on the legislature. I want to talk not about the 2021 failed constitutional amendment, but the 1966 amendment. And the people were told what they were voting on. They were voting on a 3-month residency requirement. That was the ballot abstract, and the actual language that they voted for to enact.
But we've abandoned, I think you have this in your brief, about the intelligent voter and what they knew, that we've abandoned that.
I want
We've
to push back on
abandoned that approach. What
Well,
applies are our rules of construction.
I agree, and your rules of construction do say that we look to the, well, so I do want to push back on that a little, because I don't think Golden goes as far as that. Golden, the issue in Golden was particular language, and it was saying if we have particular language and there's a question of, does exactly how this applied to the mayor of New York under the New York Charter of the specific language, we're not going to pretend that the voters had this intricate knowledge of statutory interpretation and would have on their own had some thought on that. But that doesn't say that the voters don't even have any concept of what issue they're even voting on, what topic. Here it's a question of, are they voting about residency requirements or are they voting about absentee balloting? Totally different subjects.
Well, they're voting on the reform to the language in Section 1.
Yes, and it
And it's whole
specifically
cloth,
said,
as you've already pointed out in your briefing,
it said
right?
in reference to a 3-month residency requirement. That is the language that was on the ballot that they were voting for. Section 1 in reference to a 3-month residency requirement. So that's what they were
If
told.
that's all they were voting about, what about the age?
What, age?
Age, the change in the age.
Oh,
They didn't understand that?
well, it's part of the eligibility requirements. It's at least in the same topic, is what I would say. But my point is that there is nothing contemporaneous where we look to legislative intent. If we're going to look at the legislative history, the two most, they've said there's not much legislative history, there's not much to look at, but the legislative history that is there, look at the sponsor's memo. If you read that sponsor's memo where it breaks down exactly, it comprehensively says what's being changed and makes no mention of absentee voting. It's just hard to conceive how someone, if the sponsor thought this had anything to do with absentee voting, it wouldn't have even been mentioned. You can also look at the 1966, the report of a joint committee on the study of the election law, where they're talking about proposed various ideas of reforms, and they refer to this specific amendment, urging the passage of this amendment, and refer to it only as involving residency
But if you
requirements.
thought that the 1894 amendment would have allowed the legislature to let people who were not absent, who were present in their election district, vote by some other means than going to the polls, if you thought that, then the change worked in 1966 is pretty small, if there's any change at all.
I mean, if you thought that, it would make a number of the amendments to Section 2 over the years prior to 1966 meaningless.
Really only one of them, I think.
Okay, well,
Which then it's the other side of the 4 that are done after 1966, right? Then you have this kind of mess where somebody or the other didn't understand the law.
So I guess what I would say is if the will of the intent of the legislature and the will of the voters matters, then we need to look at the full context in 1966 and what people thought they were voting on. And again, I think the question was asked before, was this an intentional change to the absentee voting, or was this an accident? I would phrase it differently. I would say, was this a secret change or an accident? Because if it was an intentional, it was hidden from the voters. If you were a voter in 1966 trying to do your constitutional duty of being a check on the legislature and approving of a constitutional amendment, in order to know that this was going to have this effect, you would have had to do a comparison of the text, identify this particular phrase, and know the interpretation that it put on it 100 years
You didn't know that it
earlier.
meant the end of in-person voting. Let me go down the rabbit hole with you. All it meant that it wasn't mandated by the Constitution. The legislature was free because, of course, Section 7 allows, right?
I'm sorry.
Section 7 allows for the legislature to determine the methods of voting, so all one would understand, right?
There had been numerous amendments specifically pertaining to absentee voting as recently as 3 years earlier in 1963. The people had been asked to vote to expand
Yes.
the power to grant legislative absentee voting. And then in 1966,
All I'm saying is that if the deletion means it's not mandatory, it allows the legislature to choose to continue with in-person voting and to make exceptions and to create the opportunity for access to the ballot through different methods. It gives greater flexibility, which at the end of the day is really the wallpaper
well, I mean, the same was
behind
true.
all of those choices.
The
is
same
to
was true
expand
of the
voting.
1963 amendment and all the earlier amendments. They were all permissive and didn't
Yes.
mandate that anything would be expanded. They gave the power to expand. What I would say is,
Well, it could very well be that the in-person voting is deleted. Once you delete that language, it's eliminated, the requirement in 66, and the legislature is now free to choose some other method, but decides not to do that for whatever reason, other than in particular categories of, for voters.
We're just saying that there's no reason to believe the legislature actually thought that that's what it was doing in 1966. And what I would say is that they've conceded that prior to 1966, this power was retained by the people over absentee voting, and the legislature had to go to the people if they wanted to expand absentee voting. But they're saying that the people gave this power up to the legislature
Well,
in
it is very
1966.
hard to read these provisions the way you suggest, given if it is this monumental in-person voting. It should say it expressly. It's very hard. And the language that gets you there is deleted and not put somewhere else, retained in some other way. It's very hard for me to see your argument.
And I would say that by that time, there was a history going back 50 years of Section 2 being the locus of absentee voting in the Constitution, and people repeatedly coming back to Section 2 to amend it, to expand it, looking to Section 2. So I think it's just the assumption that people in 1966 would have put this weight on the change of wording in Section 1 as having this significant effect is just, there's no evidence that anybody had that thought at the time. There's no reason to think that the people thought they were giving up this power in 1966 just because of some change of language.
Thank you.
Thank you.